Hmm.
The death of the elder mother of the applicant. Then it was totally the death of.
List करे दिया. Give a memo to that petition to the state council so that you will obtain instruction. No?
Yes.
What happened to the state council today? None of them are there.
Please give it. You know the phone.
Wait for some time.
Wait.
Order of the single bench your lordship, where the service of the respondent was quashed and your lordship, he was reinstated. The said challenge, said order has been challenged, your lordship.
Give it memo. Please give it. He made a mention, Mr. Nayak, that the elder brother of the petitioner has expired. And
Father.
You have to take instruction and it will be listed tomorrow. We have fixed it. Huh? Which police station we just said? No, take.
Give the particulars of police station and all. Application, where is your application? You have given?
Give
Give
an extra copy, another copy to. Yeah.
Supplemental list, item number 1.
What is this?
Has convicted on the subsidy based of some life increasement.
Like admit for the trial photo. Easier order pass. Yes, magic.
Item 2.
The present applicant was convicted of offence 302 of IPC and life conviction.
Yes, next.
Item 3.
Admit. They engage for the theatre taking. She serially very good, huh? Nua list as was, what step by the region? No, ସେ ଦି ଜଣ ପିଲାଙ୍କୁ ଇଏ କରାଉଛି ଆଉ ବାକି ସେ ବୁଝିକି କହିବେ ତାଙ୍କୁ ଅନ୍ୟମାନଙ୍କୁ ସିରିୟଲି କରି ଦେଇଯାଆନ୍ତି.
Item 4.
The current account of the company was converted to the overdraft account. There was no mortgage. But when account became NPA, they issued 32 notice. I requested the bank to supply certain documents because since there is no mortgage, the loan is unsecured and the debt is also not secured debt. Why they did supply the?
You are appearing.
I'm appearing, Millard. There was a settlement. Not
And the
settlement.
Yes.
Settlement amount was to be paid in 4 quarterly installments.
Yeah.
First was to be started by June 25. He failed in that. He asked for details of the amount, settlement amount. That also be provided on 30th June. So everything is there, but he is not paying that one. He is not complying with the settlement amount.
Then we
It is
refer the matter to the. We are recording your submission
not that.
and referring. Please pass on first. Mediation. Referring.
So mediation, and I humbly submit, mediation is for to arrive into settlement. Here settlement arrived. Parties agreed to make payment, but he failed in that. What the settlement, the mediation will do. That's my humble submission, subject to lordship's consideration.
What you have written?
Now the 9th June letter, that is the amount 58,48,367.
and 4 lakh upfront to be paid, that was paid. Thereafter, it was to be settled, on to third paragraph. Bank cannot be withdrawn until repayment of the overdraft account
Mhm.
full
Go on.
in third paragraph
Hmm.
of 9 June letter, 9 June 25 letter.
4 lakhs he has paid.
2 lakhs is deposited, initial one. Thereafter, the first installment due by June 25, that to fail. It was to be paid in 4 quarterly installments right up to 26.
Hmm.
So till March 26, June 25 to March 26, paragraph 3. So the first installment of June failed, not paid.
Now suppose now he'll say that I'll comply. Will you be accepting that?
That he can approach to bank.
That is why
That is from June to August. No, June to August, whatever the little interest will be there, that he can consider and it can be settled.
Intend to send it.
Yes, will you comply with the?
My friend is submitting a letter, I don't have any
So
instruction.
your client must have.
You take it.
Your lordship may take up some other day.
We are referring it to the mediation.
So, because they are proceeding under the SURFACE, since it is a
Forget, now the letter has come and you have to just make a payment.
Mr. Panigrai, learned counsel for the bank, has hands up a letter dated. What is this letter? 9th June 2025. As per which is taken on record. As per the letter, the parties in the petitioner in deed has arrived at a settlement with the banks and proposed to pay the total due, the final settlement to the tune of 58 lakhs 48,367.65 as on 2nd May 2025. He has also paid the upfront amount of 4 lakh rupees. However, the agreed installment fixed between the parties has not been complied. When the court put a query to
The chitti, I see Bharat को चिट्ठी पर दी 11 जो so and so issued to the bank for clarification of this one. So it is a clarification of the
Mr. Panigrai has also placed on record a letter dated 30th June 2025, whereby the clarification was sought by the petitioner from the bank regarding the payment of the installment. The letter is taken on record. Be that as it may, the fact remains that there is a settlement already arrived between the parties, and the parties are duty bound to comply with the terms of the
I
settlement.
have no instruction.
But this is letter.
Because
Settlement.
my friend.
In that 1 minute, in that view of the matter, we feel it appropriate to send it for the mediation. Mediation. Accordingly, the matter is referred to mediation, so and so, and we will dispose it.
Stated that you installment is
The first installment, the first installment fixed for the month of June has been defaulted by the petitioner. We will dispose it. No, report will come.
And my prayer is for supply of documents.
Mortgaging the house property of his mother. The petitioner has paid my lord 8,40,000 out of 10 lakhs my lord. He sustained a heavy loss my lord
Indian.
of COVID my lord in the year 20 my lord.
Reserve Bank of India, some code.
State Bank of India and the State Bank of India CTH.
Opposite party of the matter.
You received the 13-2 notice under
Madam.
Annexure 2 series.
Madam.
What you have done? And it is a 6/2/2025 letter.
Have you challenged this, have you challenged this annexure 2
My lord,
before DRT?
no, my lord.
Then
Mediation may be.
Section 17, you have to file against this.
Kindly refer to mediation, my lord.
Mediation, they should be agree. And you are appealing for bank.
no. And collector's letter is there, Annexure
Or my lord.
4. Take notice that the authorized official so has filed an application under section 14 of this law. The same has been posted for verification of the documents. You are therefore directed to appear or through your counsel who also 7/7/25. This is the latest one.
My lord.
You are Mongol Das, it is addressed to you.
I have appeared before the collector, my lord, on this case.
Collector, deputy collector has addressed this letter to you and one Rama Devi Das. That's the letter.
Mother of the petitioner.
Yes.
Whose house property was not.
So now alternative remedy is available. What can be done? They have taken position and most likely the third party interest must have been created. You are not also adding that person as a party. 14 application has been filed, notice has been issued to you.
After alternate remedy, you write down the declared counsel or the petitioner is ready and willing to settle the dispute through mediation. The DRT may exclude the possibility of mediation before deciding the matter on merits. DRT can also do that.
14 stage ଆସିଗଲାଣି letter ଅଛି component is
That part also you write so that DRT can also send it to this.
Yes. Disposal. Disposal. Next.
Item 6.
May I please, Madam? In this case, challenging the order of landed Kate Matter, similar case, your lordship fixed to another day, kindly let this matter along with this matter.
What is clear here? 17/1/25.
Madam, page 84, madam. Infinity, annexure 3, start from 83, 11 page 84. Para 3, madam. In course of hearing, learned counsel for the applicant has submitted that on similar ground, the prayer of legal heirs of late Gangadhar Pally was rejected, which was challenged before this tribunal in OA number 379 of 2024. And this tribunal, after taking into consideration the facts law by order 3/12/2024, granted the relief to the applicant therein. The said case was
Yeah, this matter, a wrong order has been annexed. The order which you.
My madam, in similar 3 OA filed before the learned cat. One is 378. That's why I am.
Let us see the.
370. That's why I am taking the matter.
This order you are challenging dated.
Same order now.
Same order je apanko prayer hochi 380 of 2020.
Madam.
Upon the order ta annex କରିଛନ୍ତି
378 madam.
378.
ଆଉ ଗୋଟେ ଫାଇଲ ହେଇଛି 379. 379 ରେ ମେନ୍ ଅର୍ଡରଟା ପାସ୍ ହେଇଛି ତାର ଆଉ ଦୁଇଟାରେ କଭର କରାହେଇଥିଲା.
Your prayer is 380 of 24.
Madam.
And also the order you have annexed as 380 of 24.
Madam.
So what is the problem?
Problem, madam, the main case or lead case was before the tribunal was 379 of 2024. The same was not listed till date. That's why I am taking the matter because the 3 measures along.
You are trying to say that there are 3 matters.
Madam.
378, 379 and 380.
Madam.
378 against 378. This is pending.
Madam.
And what about 379?
379 also pending, madam. The diary number is there, main number is not.
Pending before central administrative.
No, before this court.
Before this court.
3 matters disposed of.
Okay, so
similar order.
This has to come on 18/8/25. All right, in this writ petition, Union of India has challenged the order dated 17/1/2025 passed by the London Central Administrative Tribunal, Cuttack Bench, Cuttack in way number 380 of 2024. The Land Council for the petitioner submits that three similar matters were disposed of by the London State Administrative Tribunal on 17/1/2025.
Two matter is 17-1 and your leading matter was 3/12/2024.
To disposed of, that is in way number 378 of 2024, comma, way number 379 of 2024 and way number 380 of 2024. WPC number 20415 of 2025 has been filed by the petitioners challenging the order dated 17/1/2025 passed in way number 378 of 2024, which is fixed to 18/8/2025. Stop. Similarly, the order dated 17/1
সেটা নম্বর হয়নি, ডায়েরি নম্বর হয়েছে, ফাইনাল নম্বর হয়নি।
Okay, put up this matter along with WPC number 20415 of 2025 in the week commencing from 18/8/2025. Yes, produce the copy of the order dated so and so, past in which is taken off the. Yes.
Item 7.
Item 7, on behalf of Mr. B.N. Pandey. B.N. Pandey.
You want adjournment? No order has been passed. But you are challenging the auction sale notice. So your remedy is elsewhere, not here. Why are you unnecessarily wasting the time? 1/7/2028 notice, auction sale notice has been issued. And you have annexed also that document. As per possession notice, which is 24/4/25. Your attention is invited from the division 30 days before publication of auction notice in your notice. ठीक है, mediation को refer कर दो तो auction है
30 days.
30 days. Your attention is invited to this one, so and hereby advised to pay the dues of the bank within 30 days of the receipt of this notice before publication of the auction notice. Otherwise, your right of redemption will be extended. 30 days মানে 30 days also পড়ে না। auction notice এলানি আমি জানান্তি
সেই alternate remedy করে কি লাস্ট লিখে দেওয়া ডিআরটিভি সেটা করে দেবে alternate remedy and the DRT should exclude the possibility of by referring it to mediation.
challenging this order.
Referring to mediation, which is national mediation for national mediation.
Translate.
Before entering into merits of the case.
Next.
Item 8.
8 minor. There direction may be made to the.
That is the 14 of the
Section 14 is pending.
1062/25 that kind of will pass that order.
14 application of the order is
With those stipulated period may be.
Put it up.
Double page number 1062/25.
Number is there 30 of 2020.
number in this case number where you 14 application or number
common order pass
common order पर जो pass है ना dispose of. Yes, next.
Item 9.
for which time may be required to substitute some of the opposite parties expired in the meantime.
Notice delivered to addressee state for substitution by sworn so not taken. Here now step kiya upon petition.
Again, in the meantime, two other opposite parties have also expired.
Who are they? ଏଠି ତ ଆସିଛି 16, 17 ଆଉ 23
Again,
ଆଉ କିଏ ମଲେଣି? You are not aware about it.
But in the first case, 15123 of 2012, I am appearing for the OP. If someone may be dead, then I will take expression and file. In first case, I
So they are to take steps for the substitution of three persons have died.
My lord.
So raise step of notice on sponsor delivered.
the meantime, 6 and 19 also expired.
No, when the order was passed, you come to the order dated 6/12/23. 6/12/23. ତାପରେ ତା ପୂର୍ବରୁ ଲେଖା ହେଇଛି 18/9/23 ରେ ଲେଖା ହେଇଛି steps for substitute ତା ପୂର୍ବରୁ କଣ? ଆଚ୍ଛା ରିପୋର୍ଟ ଅନୁଯାୟୀ ଫାଷ୍ଟ ଅର୍ଡର ପାସ୍ ହେଲା 18/9/2013 ରେ 2013. The steps for substitution by so and so shall be taken within 2 weeks, failing which it's on. ତାପରେ କଣ ହେଲା ଆପଣ କଣ କଲେ?
Earlier, let Miragos was appearing in this case.
ତମେ ସେ କଥା ଜାଣିଛ ତାପରେ କଣ ହେଲା ପୁଣି ଆଉ ଗୋଟେ ଅର୍ଡର ପାସ୍ ହେଲା 6/12/2023. An order was passed on 18/9 to take steps for so and so, but the same has not been taken, nor the learning council for the field.
I have been instructed recently, my lord.
तापर SR notice on the petition has not made back. Registry director who notice to the petitioner by registered post.
Is anything survives in this petition?
Bring order to front.
If you
So 2013 order, whosoever appearing we do not know, but fact remains that an order was passed in the year 2013, 18/9/2023, that you are to take steps for substitution vice deceased who are the opposite parties number 16, 17 and 23.
My lord.
And in the meantime, almost 12 years have passed and you have not taken any steps. In the meantime, council has changed.
No, but
And
council not changed. Let Miragos was appearing.
whatever it may be. So if you
See,
are not
expired,
taking steps, why we'll keep this matter?
I will file substitution petition and be ready for final hearing.
Then we'll dismiss this case so far as this in respect of these three persons are concerned.
Oh, this is arising out of injunction. Let us see whether injunction was sought against these people, those who have died. If that is the case, they have died, then fresh call action, let them file. So
Interim order their injunctions.
that is why it will go on and on and on. Never ending process.
Why we are recalling that interim order? We are giving you 1 week time. If you take steps, then we'll see. You are challenging the order passed in the FAO number 59 of 2007 by the learned ADJ Patel. And in that order, the dismissal order of the Civil Judge Junior Division that was confirmed. So if we come to that particular order, 1/12/2024. What is the status of that civil suit? 77 of 2006, which was pending in the court of, because it was an interim order and the proceeding must have gone ahead.
Pending.
What was your suit?
It's pending.
No question of pending. No,
The suit itself is, I don't think is.
Interim order was there.
no interim order ही नहीं जे suit को stay ही नहीं. Just maintain status quo, that is over the disputed property, that's all.
What kind of
The order is.
DT of Muslim DT? Where is the question of having a Muslim DT? I don't know. Marfaddar of a DT of a, what kind of suit is this? Only judge. Para order, para 2, para 3 order, 18 order, para, and it's a 2, para 3. I think this contains of the appellant that he is the president of Syed Mansoor Sahib Dargah and Islam Managing Committee, and the respondent claiming themselves as the Marfaddar of a DT. In a Muslim law, there is no DT at all. DT are bent upon to grab the property of the alleged DT by making permanent constructions for the purpose of the business with sole intention to let out the complex rent. This suit is doubtful suit.
Start first time of the law, that was take 1 week.
Interim order वगैरह को that no step has been taken. For the interim वगैरह को that's automatically everything will go well.
The
It is pending since 2012.
on 18/9/2013, when the matter was placed before Land Register Judicial, steps for substitution by deceased opposite party number 16, 17, and 23 were directed to be taken within 2 weeks,
Along with the first step to serve.
along with press steps with correct present address for service of admission and stay notice on the opposite party number 10B by registered post with AD within 1 week. And failing which, the matter was ordered to be placed before the bench. The matter was then listed on 4/1/2023. And when it was listed on 6/12/2023, and nobody appeared for the petitioner, this court finding that the steps for substitution vice opposite party number, deceased opposite party number 16, 17, and 23 have not been taken, directed the registry to issue notice to the petitioner, informing him to take necessary step for engaging a counsel to conduct the case. And the interim order dated, interim order passed earlier was directed to continue.
Interim order dated 18/10.
18/10/2012.
Shall continue.
Matter was then listed on 7/12/2024. And on that day also, the interim order was extended since the SR of notice issued by the registry to the petitioner was not back
Non-appealable.
and nobody also appeared for the petitioner. The Mr. Mahanti, Land Council, submits that he will take steps as per the order dated 18/9/2013 for substitution, by so and so by next week. And also to take steps with correct present address for service of admission stay notice on opposite party number 10B. So,
Extension is not continued till 29 April 2025.
so
Continue.
when the matter was listed on 7/2/2025, the interim order dated 18/10/2012 was directed to continue till 29 April 2025.
Thereafter, it is not.
Thereafter, the matter was listed, but the interim order was not extended. So, the prayer in this writ petition is to quash the order dated 1/12/2011 passed in FAO number 59 of 2007 by the London Additional District Judge Cutter in confirming the order dated 3/4/2007 passed by the London Civil Judge Junior Division Salehpur in IN number 96 of 2006, which arises out of CS number 77 of 2006. The London Council for the parties could not apprise this court about the status of CS number 77 of 2006. Let a report be called for from the London Civil Judge Senior Division, so and so, about the status of the aforesaid suit. Matter where the file be placed before rest of judicial. Send the email to this one. So, put up this matter on such and such day. We are giving you the time now for 1 week, as you said.
2 weeks.
No question of 2 weeks. On that day, we'll pass necessary orders.
The connected material is it. The interim order will continue.
Right.
No, it was not extended earlier. We will not extend.
Yes, sir. We extended.
It was not extended.
Connected material.
What is the
1951/2024.
What is this? Arising out of the same suit?
No, my lord. That is arises out of order passed by the Wakaf Tribunal. The self-same issue, the suit was filed seeking injunction, and here the declarations.
Suit is not maintainable then.
Yes, sir. I am opposite party in that case, sir. The suit was proceeded, order was passed, challenging that order, the first writ application
This
there.
is Waqf
And
property
during
and
pending
suit
of that suit, Your Lordship, they have also filed a way before the Waqf Tribunal. And the second writ application, the order passed by the Waqf Tribunal is under challenge, Your Lordship. And the interim order, since Your Lordship, 13/10/14, Your Lordship, that is there, but the subsequently continued, Your Lordship. Last 7/2/2025, Your Lordship, the interim order was.
You are the defendant in the suit. You are the
Yes, sir.
defendant in the
Yes,
suit.
Your Lordship. In both, in the suit to where we dependent, in the way where the respondent.
This, you were challenging annexure 6.
Minus, annexure 6 plus
Annexure 6 is
47,
the judgment of the
Waqf Tribunal.
Waqf Tribunal.
Minus.
So that is dated 27/9/2014. In that particular, who are you in that? You
We are the
plaintiff?
Marfodas, Your Lordship.
Oh,
You are the respondent here also.
Yes,
And who is the plaintiff here in
the same person, Your Lordship. The
Same
suit
person.
rep- the
He has filed the
plaintiff-
suit also, this
Yes,
also.
Your Lordship.
Then that writ has to go. If you resorted to that this remedy. Has he disclosed that suit was pending?
In the tribunal, Your Lordship, I think the examiners. Whole matter.
That is very important. Whether he
Yes,
has said
yes.
that I have already resorted to suit proceeding.
My Lord.
Has he said that before Waqf board? Hmm? We know that, but he has already filed a proceeding in the Waqf board, and he has filed the suit there also.
Suit in there
Suit
and
goes then
the two proceedings is
completely vitiated.
that is why.
Yes, that was the
2006 suit.
Hmm.
We are just calling for a report because it might have, some order might have been passed, who knows?
They might have closed down.
Or close the case, that is why.
Who will
That
have
was
to
placed to the
unwind
court of the tribunal, but the issue, Your Lordship, issue number 5, there is question of residue cut was raised, Your Lordship.
The
Let the report come then. See.
matter be listed, the connected matter like this, WPC number so and so. List this matter along with WPC number so and so. Date the 18th तारीख है 18th of August 2025 है ना? Interim order dated so and so.
13/10
next date. Yes.
Obliged, Your Lordship.
Item 10,
28 तारीख ଆସିବ 18/8/2025 both the matters.
item 10,
With the petitioner here.
Let me kindly have a glance to the last order, order dated 19/3/2025. Here, I am reading out the order. Mr. Samuel, counsel for the petition submit that outstanding dues as mentioned in the informed notice under section 13(4) of the Securitization and Reconstruction of Finance Asset and Enforcement of Security Interest Act 2002 is rupees 2,84,36,603. Out of the above amount, rupees 1,20,00,000 towards subsidy released by the government has been deposited with the bank by Horticulture Department, Government of Orissa, opposite part number 2. The petitioner is ready and willing to pay the rest amount. It is submitted that the petitioner cold storage started operation in the month of January. Thus, at this stage, if the possession of property is taken over and delivered to the auction purchaser, the petitioner will be highly prejudiced. Considering the fact and the petitioner is ready and willing to pay the outstanding, this court issue notice to the opposite party. Mr. Mishra and additional standing counsel accept notice on behalf of the opposite part number 1 and 2 and prays for adjournment to take instruction in the matter. Mr. Samuel and counsel for the petitioner prays for taking notice to the OP number 2 and 3 by special message. Accepting such submission, this court direct that the cost shall be assessed and deposited sanction. And accordingly, I have deposited, and the next day I have deposited the cost. Special message.
Leave it, how it will be maintainable here? 13(4) notice you are challenging in a writ petition.
My lord, this is not an ordinary loan under the, this is under a scheme. Here, the on the completion of the work, state government shall pay the subsidy of rupees
That
that is
subsidy
30
120 is paid.
120. And they approach, the bank authority approached the DRT by filing an application under section 19 to issue the certificate to proceed against the loanee. That is pending before the DRT. Without any final order there, they take resort to 13.4, which they cannot, because here it is not.
Approach the tribunal.
Those things you can tell the tribunal.
Why will?
The only thing is, state government has deposited this subsidy.
That is already there, but when another question.
I am ready and willing to.
That you stated in 19/3/25, we are in the month of August. You have not paid a single pie there.
They have not appeared before this honorable court. Despite service of the notice to a public authority, public bank, this honorable court issued a notice on a special messenger. They did not have to.
No, you have to pay the amount to whom?
To the
person.
bank.
Bank.
The moment, my lord, the entire amount, the government has deposited the subsidy. If I am ready and willing to pay the balance amount minus the subsidy. That is the only prayer.
Have you deposited any money before the Punjab
Yes,
National Bank?
I have deposited substantial amount. About
Balance amount here
yes, your lordship.
by Monday.
By Monday deposit, we will send it to mediation.
Monday.
You are ready and willing, you have been telling since a year, so many.
Your lordship, now they have issued an.
That's the whole difficulty.
Yes,
You are ready and willing, and when you want to pay, you don't know.
Your lordship may allow me 15 days time.
That's the problem.
At least 15 days time, your lordship allow.
That you have already been granted 4 months time.
No,
More than 4 months.
The state government is to take instruction whether they have deposited 1 crore 20
That's
lakhs or not.
But see, the writ petition is as such is not maintainable. Indulgence can be given if you deposit ready and willing, deposit it, we'll send it to mediation and sort it out.
Yes.
As simple as that.
I say, but your lordship may grant me 15 days time. It is a huge amount.
No, it has already been granted to you. But 15 days, you have been granted already more than 4.5.
No, pursuant to that advertisement, pursuant to that auction notice, nobody appeared. Now they issued another notice by reducing the amount. If your lordship, I will take your lordship to the amendment petition. Initially, it was 2 crore 75 lakhs. Now they have reduced the amount to 1 crore 94 lakhs. Your lordship may kindly have a glance.
After adjusting that 120.
No, not up. 275 minus 120.
And with interest and all. See, we can't go into the calculation.
I am not saying for that. Only thing, let the state government say whether they have deposited the amount or not.
No, that is an order has been passed also.
No, that is my submission has been recorded. My submission has been recorded that
that's the reason minus 120 from 284 as per your statement. You deposit, we'll send it. Whether it is they have deposited or not, that will be decided.
Take your remedy before the DR.
That's a better way.
Take instruction. Can it be on
Take in Monday.
Monday. And take instruction.
On 19/3/2025, when this matter was listed, and it was, and this court found that out of the outstanding dues of rupees 2 crore 84 lakh 36,603, as per the 13/4 surface I notice, 1 crore 20 lakhs rupees has been deposited by the government or released by the government towards subsidy, which has been deposited with the bank by the horticulture department, the learned counsel for the petitioner made a statement before the court that the petitioner is ready and willing to pay the rest of the amount. When we put a pertinent question to the learned counsel for the petitioner as to after the order dated 19/3/2025, any amount has been paid by the petitioner. With the bank, the answer was in negative, negative. It is also brought to the notice that another matter is pending before the DRT, which was instituted by the Punjab National Bank. The land counsel for the petitioner 6 times till Monday to obtain instruction as to whether any amount has already been deposited by the petitioner. Put up this matter on 11th of August 2025.
About 1 crore 60 lakhs you have to deposit.
Yeah.
Now, my lord, they have issued the notice by fixing the amount at 1 crore 74 lakhs.
Yes, sir. It likhi diyantu SR of special messenger notice returned from opposite party number 3 and 4 after valid service stop non-appears for opposite party number 3 and 4. It upper likh deba hala. Yes, next one.
13 days delay to file the appeal, my lord. 13 days delay.
What is this appeal for?
My lord, conviction for life, my lord.
B02. Yeah. IA number 2086 of 25. There is an application for combination of delay. The stamp reporter has pointed out that there is delay of 13 days in filing this criminal appeal. Hearing the land counsel for both the parties, since the petitioner has been sentenced to life imprisonment, we are inclined to condone the delay. Accordingly, delay is on the IA disposed of hard admit call for the trial court report. Yes.
Another appeal also filed the JCR.
এটা কোন হয়েছে অর্ডার কোন কিছু হয়েছে আচ্ছা কপি অফ দি ট্রায়াল
15/5/2025
ট্রায়াল কোর্ট রেকর্ড আসছিলেন না আচ্ছা এটা এখন সেম কেস রাইজ করছি
চন্দন
Another appeal.
চন্দন সোনা নায়ক
জাস্ট এটা হচ্ছে আপনার 28/3/2025 কেস নম্বর হচ্ছে CTSS 106/2016 এর পরে আছে মেনটা ওখানে এটা জাজমেন্ট
Another appeal, my lord.
28/3/2025 same
Bipronike and Chandan.
Lucky it appears that the co-accused has preferred JCRLA number 75 of 2025, which has been admitted on 15/5/2025, and the trial court records have been called for. Before, if the trial court record has not been received in the said JCRLA number 77/2025, then can only the trial court record would be called for. Yes.
Item 12.
I may be allowed to place this matter through BC my lordship.
Yeah.
My lordship, this is the appeal for challenging the judgment dated.
What is
My
the
lordship,
conviction case?
yes, my lordship, in 302 case. Delay of 31 days, my lordship,
Just a
to file this appeal.
Yes, life imprisonment. Same type of for the order ta hobo. Hala. Adere the delay hochi 32 days. Hala. Delay to be condoned, admit call for the trial court report. Other kisi connected matter then normal. No. Delay condoned, I to dispose of kori. Yes, next.
Item 13.
Yes, my lordship.
May I please? The order of ombudsman, my lord. Next, sir, age that is under challenge, which has been passed in contrary to the decision of the Honorable Apex Court in the judgment of Assistant Engineer versus Ramtola Khani versus. Here in this case, Miller, that
Was challenging annexure 8.
minor.
Annexure 8 is the order
It's
dated 28/8/2020
minor.
of the ombudsman. Hello?
Miller.
Who initiated that case?
That as that there was a suspicious withdrawal of the arrear amount of 83 consumers.
You are the respondent in that.
Miller.
Petitioner
I was the
was on Santosh Kumar Singh.
Miller. Santosh Kumar Das.
Okay. What was the prayer in that case?
That he challenged that being agreed with the order passed by the grievance redressal forum. That is annexure. That is annexure.
Yeah, what was the order?
What was the
Miller.
arrear dues or what?
Arrear dues. There are suspicious withdrawal of 83 consumers. Suspicious withdrawal from the database of the website of the licensee also. That was for the year August 2020. That was detected. And the person who was in charge of that account, the accountant, Jitendra Nath, he was disciplinary proceeding was initiated against him and he was removed from the service. In January 2023, a demand was raised to the consumer by issuing notice that if you have any,
He was a single consumer.
all consumers, 83
This is
consumers,
one of them.
This is one of them.
this is one of them.
Yeah.
You issued a notice, annexure 2 your lordship, that if you have paid that amount, your arrear outstanding up to August 2020, that 21,400 rupees, then you show the receipt so that that will be adjusted and we will not proceed against you. He did not. He moved to the grievance redressal forum. Grievance redressal forum rejected his application. That you are liable to pay that 21,400 rupees. That you are liable to pay.
No. The amount he has not paid.
He has not paid.
Okay.
That, but it has
But
withdrawn from the
according
database.
to him, he has paid that amount over.
My lord,
But what is the case of the petitioner?
case of the petitioner is that since we have raised a demand 21,400 rupees to him, that you pay that amount because you have not paid, but it has been suspiciously withdrawal from the database of the licensee. Therefore, you have to pay. Challenging the same, he moved to the grievance redressal forum. Grievance redressal forum rejected his application. That hold that in view of the judgment of that Honorable Appeals Court Ramtola, since first due comes on January 23, then you are liable to pay that amount. Then he moved to the ombudsman. You will also kindly glance the analysis that has been made in 43. Finding and analysis.
Ultimately, the order was passed that you are to withdraw the amount of
Exactly.
rupees 21,400
Minor.
from the bill of the petitioner
Million.
and serve the revised bill.
Minor. That we are challenging here.
What is the ground of challenge?
Because it is contrary to the judgment, the finding reached that by the ombudsman, that is contrary to the judgment of the Honorable Appeals Court in Ramtola and Prem context. The judgment that I am supplying the copy of lordship. The section 56(2) of Electricity Act 2003, that was interpreted. And the Honorable Appeals Court held the demand that was raised first to the consumer, the period of limitation 56(2) will be calculated from that. That is a lordship 56(2) that is passed to lordship. Yes.
Which are the relevant provisions?
56(2) section 56 of Electricity Act 2000, subsection 2, surplus 2.
Subsection 2.
Million. That says
Now you read the
enter provision.
ah,
It will correct us. The 56 says disconnection of past
disconnection of supply in default of payment. Okay.
where any consumer neglects to pay any charge for electricity or any sum other than a charge for electricity due to him, to a licensee or the generating company in respect of supply, transmission, distribution, or wheeling of electricity to him, the licensee or the generating company may, after giving not less than 15 clear days notice in writing to such person and without prejudice to his rights to recover such charge or other sum by suit, cut off the power supply and for that purpose cut or disconnect any electricity supply line or other works being the property of such licensee or the generating company to which electricity may have been supplied, transmitted, distributed, or will or may discontinue the supply until such charge or other sum, together with any expenses incurred by him in cutting off the reconnecting the supply, are paid but no longer, provided that supply of electricity shall not be cut off if such person deposits under protest A, an amount equal to some claim for him, or B, the electricity charges due from him for each month calculated on the basis of average charge for electricity paid by him during the preceding 6 months. Whoever is less, pending disposal of any dispute between him and the licensee. 2, that is important also. Notwithstanding anything contained in any other law for the time being in force, no sum due from any consumer under this section shall be recoverable after the period of 2 years from the date when such become first due, unless such sum has been shown continuously as recoverable as arrear of charges of electricity supplied, and the licensee shall not cut off power supply of the electricity. The first due that was interpreted in their judgment, your lordship, that's judgment. I've supplied it.
Past due. Which paragraph?
Mine. The finding, your lordship, kindly glance. The point 6.9 at page 656.
6.5?
Page 656. 6.9.
Yes.
The liability to pay arises on the consumer electricity. The obligation to pay would arise when the bill is issued by the licensed company, quantifying the charges to pay. Electricity charges would become first due only after the bill is issued to the consumer, even though liability to pay may arise on consumption of electricity. Then 7, your lordship. The next issue is as to whether the period of limitation of 2 years provided section 56(2) of the Act would be applicable to an additional or supplementary demand. The prior, then there is the interpretation of the section.
Concluding.
Concluding, your lordship, 7.5, your lordship. Next page. The period of limitation of 2 years would commence from the date on which electricity charges become first due under subsection 2 of section 56. This provision restricts the right of the licensed company to disconnect power supply due to non-payment of dues by the consumer, unless such sum has been shown continuously to be recoverable as arrear of electricity supply in the bill raised for the past period. If the licensee company were to be allowed to disconnect power supply after the expiry of the limitation period of 2 years after such become first due, it would defeat the object of section 56(2). Then 8, your lordship. Section 56(2), however, does not preclude the licensee company from raising the supplementary demand after the expiry of limitation of period 2 years. It only restricts the right of the licensee to disconnect power supply due to non-payment of dues after the period of limitation 2 years has expired. Nor does it restrict other modes of recovery which may be initiated by the licensee company for recovery of the supplementary demand. The first due means when we raise the demand to the consumer.
When the bill is raised.
In January 23.
That is the first thing.
That was the first thing. That we raised because the proceeding was initiated against our officers. The Jitendra Nath OIG3, and he concluded that he was involved in that conspiracy, and he was removed from the service. Only after removal his service.
What conspiracy?
That the ID and password was with the Jitendra Nath, who is our staff, and he fraudulently withdrawn that 83 consumers area outstanding from the database, licensee database.
Achha.
Because it's a dereliction of duty.
But why have you taken action against only one consumer?
No, other one we have issued. other, you know, we have issued notice to
all of
other
them.
consumers.
Oh.
Other have paid also. Other consumers, they have paid. That
But
this consumer has
any
not
such
paid.
matter is pending before this court.
Mane-
Any such matter is pending before this.
No, no.
And this is the first.
This is the fact.
All of them have paid except him.
Many of the have been paid.
No, whether any further application is pending before the
No,
ombudsman.
no.
So this is the only.
This is the only one. Your Lordship, kindly glance. We have issued notice. The page 21, Your Lordship. In order to follow the principle of justice, before deduction of that amount, debit that amount from the consumer account, we issued a notice to him. That is page 21, Annexure 1 series. With reference to subject cited above, it is to intimate you that on verification of available records, it is found that an amount of such and such has been withdrawn from your electricity bill for the month of August 2020 against the consumer number such and such, inadvertently, without any justification or basis, which is illegal and recoverable from it. Hence, said amount such and such is to be debited, demanded in consumer account of such and such in the billing month January 2023 and to be paid by you. If you have any justified legal objection, then the same may be submitted to this office within 7 days from the date of receipt of this demand notice for consideration in accordance with law, failing which decision taken in this regard shall be stand legally good. That next page, Your Lordship. We have issued many consumers. I have only as the evidence, I have one sheet I have, Your Lordship, given. That his name also, he has also received.
Who is appearing for consumer?
In fact, notice is sufficient, but he is not appearing.
Notice is sufficient.
Notice is sufficient. Noting is there. In the cost title, there is noting that notice also.
You have to dispose of finally. This amount is, what is the amount?
21,400 rupees.
So
But it has wide reportation. 83 consumers, if you will not see.
No, so far as we are proposing that that why not the matter be referred to the mediation because of this paltry amount is there.
And he appeared not, they could have been.
No,
He's not
they
appearing.
again press notice will be go. And once you know that it is in the mediation way, some so.
Legal issue will not touch.
We are not touching them. We are giving him a chance. Let us see that.
In nature of dispute.
That's not whatever you mediation will go.
Can leave the service complete. Service complete.
124. And that's the 4/120. In this matter, notice was issued to the sole opposite party on 4/124. And the land counsel for the petitioner filed requisites for issuance of notice. Even though the notice has made sufficient, but no one is appearing, even though the matter has been listed thereafter on 1/3/24, 29/1/2025 and 24/3/2025. The learned counsel for the petitioner submits that the outstanding dues of electricity charges against the opposite party is rupees 21,400. In view of the nature of dispute involved in the case, they जो order ta ye kar debe and In the mediation, fresh notice to be issued to the opposite party. Right? Yes, and is to submit the report of the next.
Item 14.
In this case, the petitioner by the Union of India challenges the order passed by the Central Legislative Tribunal. The petitioner Union of India
Yes.
challenges the order passed tribunal.
Annexure 3.
Annexure 3.
Okay. What was the prayer of the opposite party?
Opposite party's prayer was not so kindly see what is in the way.
Have you annexed the?
Yes, my lord, I have annexed page 57.
Let us come to the relief sought for.
Page 57.
57.
My lord.
Maybe
The-
was to the order dated so and so. What are the orders
These
dated?
are the orders, my lord. Orders, my lord, the disciplinary
Or
authority.
disciplinary proceeding was initiated.
Disciplinary proceeding, he was dismissed from service.
Okay,
My lord,
that,
he challenges the order passed by the disciplinary authority, affiliate authority, revisional authority.
okay,
and-
then with a further prayer to reinstate. Now, what order was passed by the London Tribunal
Lone tribunal, Lord
in
Supreme
Annexure
Court.
3
The operating part
at page number
268.
268. I'll come to that. Paragraph number 40. Please place it.
In view of the law stated above, the law tribunal is not convinced to pass the charge memo, the DA and the AAS order. PML disciplinary authorities and
Next.
however, on examination of the facts and law discussed above, this tribunal is convinced to those injustice was caused to the applicant in the decision-making process of the matter, especially by the revisional authority by the order dated so in compliance of the order of the RRT dated 3/6/2013. The law and tribunal is also convinced felt that the punishment of compulsory retirement is shockingly disproportionate, harsh to the charges leveled against the applicant. Hence, the order of revisional authority dated so and the letter dated so are hereby passed, and the matter is remitted back to the revisional authority, General Manager, East Coast Railway, Bhubaneswar, for suitable modification of the punishment other than dismissal, removal, compulsory retirement, and issuance of consequential order to the above effect. While considering and passing the consequential order as directed above, authority concerned shall also deal with the matter relating to treating the period and payment of service and financial benefits from the date of dismissal till the fresh order is passed. Since the considerable time has been lapsed, in the meantime, to avoid further delay, the concerned authority is directed to complete the entire drill within a period of 45 days from the date of receipt of a copy of this order.
So no stay order has been passed by this court,
No,
and the period which has been stipulated, that is already over.
that is
Any contempt petition is pending?
Well,
Any contempt petition against you is
yes,
pending?
my lord, the content petition is pending. I have also filed an application IA before this honorable court that my lord, for further staying.
What he has done for which you
My lord, the
removed him from service?
my
What
lord,
is the
yes, lordship kindly see page 69 the charges.
because yet it has been observed that it is shockingly disproportionate
My lord,
to the charges level. So what are the charges?
lordship kindly see page 69.
No, in the impugn order also you get in the second
My
paragraph.
lord, some. My lord,
In the impugn order also you get in second paragraph, the article of charges.
yes, my lord.
Then just
That
read.
is, my lord, that is with regard to he has, something in the, my lord, he had submitted an application to the Honorable President of India, my lord, against his order of transfer, seeking transfer and against the order of transfer, my lord, he had directly bypassing the forum of the
This is
approaching
first charge.
authority, he has, my lord, which is unbecoming on the part of the employee. And also, my lord, he has unauthorizedly remain absent. That is the second charges. And my lord, another when
No, which charge has been proved? You just tell us.
My
There
lord,
are five article of charges.
My lord, kindly.
So
take
which one is been proved?
1 and 2, my lord.
1 and 2.
My lord.
So one ta hochi kon hola?
That is my
Direct
lord.
letter to president.
Direct letter.
Directly
And
and also
two ta kon?
2 is my lord remaining absent.
Two ta kodi remaining after.
None.
Article 2 ta president secretary Jena body
President secretary, sorry.
indulged in
Declined
one
with-
disrespectful reply using improper language in. So these are the
Two
two
charges, my lord, that has been proved.
is it correct? You are for the.
My lord.
So out of 5 heading of charges, only 2 has been held, have been proved against you.
No.
Yes?
All.
All. Getting proved.
Article 4 is that unauthorized absence, my lord, of saying that is 7 days, my lord. Let him complete, I will share.
No, we have actual aspect of the
Mile.
भूल हवा कथा में ना चार्जेस टा होची 5 हेडिंग रे अछि तो केतेटा प्रूव हे जेति तामे पचारजु से कहउचंदी दीटा आपण कहउचंदी 5टा तो
All the charges are proved. Yes.
Page 145, my lord, the punishment order of punishment. Page 140.
145.
Not
Let us see.
the last line. All the charges proved.
Prepare one. 140.
Yes.
Page 145.
Yes, yes,
Last
yes.
line. All the charges proved.
Very clearly, all the 5 charges mentioned in this one show have been proved with when beyond the front is offenses committed in violation of non-so are very serious in nature and so on.
Yes.
Right.
So
Thereafter, he filed appeal. In appeal, my lord, appeal was upheld, my lord, confirming all the, my lord, the charges as well as the punishment awarded against him. Thereafter, he filed revision. Before the, my lord, complaint of the revisional authority, while there is a provision, my lord, as per the railway employee, my lord, conduct and appeal rule, my lord, there, he has to file preferring appeal. He may make a request to the revision, or he may make a request to the revisioning authority for sending the matter to the railway rates tribunal. There is a tribunal, my lord, railway rates tribunal, for his advice to the revisional authority. Well, that is the provision. He may give the advice to the revisional authority, considering the entire matter appeal, revision, everything, all the documents will be sent to. And the revisional authority also referred the matter to the revisional, the railway rates tribunal. Railway rates tribunal, lordship kindly see the annexure, my lord, senior has annexed in his counter. They have not annexed it. Well, on page 10 of his counters.
Which annexure?
Advice given by
Counter which annexure?
Annexure A of the counter, my
A.
lord, senior. Page 10 was.
the tribunal, according to him, that it was shockingly disproportionate. So can a court can hold it or not that after assessing that this is the articles of charges, 5 charges are there, and this is the punishment imposed. So according to the court, it is shockingly disproportionate. So can a court hold like that or not? First tell us.
That is, my lord, very limited. My lord, the Honorable Appeal Court's judgment to that effect, my lord. My lord, the courts, my lord, while assessing the punishment, my lord, it is very limited. And my lord, that has been also quoted by the Online Tribunal in this impugned order of the tribunal, my lord. The exceptional cases where the court finds, my lord, there is any gross violation of the law, my lord, and any provision has been and procedure has
So, ଏଠି ଚାର୍ଜେସ୍ ଦେଖିଲେ ଆପଣ ଗୋଟେ ସେ ଛୁଟିରେ ରହିଯାଇଥିଲେ କେତେ ଦିନ?
1 week.
1 week.
1 week without permission, number one.
Right.
Number two, he has represented not only to you but also the president.
President of it.
So these are the two main
Right.
allegation against him. So that is how he has said
Well,
that.
the tribunal, my lord, in the improved paragraph 14, my lord, clearly held there is, my lord, no interference to the appellate order, punishment order, as well as the, my lord, appellate and punishment order. Clearly, my lord, hold on tribunal. This is very limited question to be adjudicated. That the law tribunal clearly held this tribunal is not convinced to quash the charge memo, the disciplinary authorities order, and the appellate authorities order.
There is no
With
dispute
regard to
about
the revisional authorities order, my lord, the revisional authority passed the order in view of the railway rates tribunal's advice.
Advice.
Our advice was, my lord, to reduce the punishment. And his punishment was reduced from dismissal from service to compulsory return. My lord, our contention is, my lord, when railway rates tribunal, there is two options for the department. My lord, either to accept the advice of the railway rates tribunal, or, my lord, to refer the matter to the railway board, or if the revisional authority they agree with the advice of the railway rates tribunal. Here, my lord, the departmental authority, my lord, the revisional authority, my lord, accepted the advice of the railway rates tribunal, and, my lord, reduced the punishment from dismissal from service to compulsory return.
The advice was for the reasons stated above.
Reason
It
stated
is
above,
more appropriate for the railway, for the revisional authority
to give
to give a
personal
personal hearing to the CEO,
to the
considering the mitigating circumstances and impose some lesser punishment
punishment.
to meet the ends of justice.
But that has not been
That's the advice.
my lord, specified what punishment will be given. My lord, it was advised to the regional authority to my lord, less the punishment.
Yes.
He was dismissed from service, and the authority, my lord, while considering the regional authority, while considering the aspect, my lord, reduce the punishment from dismissal from service to compulsory return.
What do we?
That is, my lord, the limited question. The law and tribunal, when views with regard to not interfering with the memo of charges,
The disciplinary appellate authority, revisional authority, advice.
Page 9 of that Annex A.
Page 9, huh?
Page 9 of Annex A, my lord. And
Why are you not taking this page numbers from which has been given here in the brief? All your numbers have been caught and now a new number has been plotted. So the page number, perhaps it is 291. It starts with
The annexure
See that-
A start with 283.
वाक्यम में लेकिन कौन से कटा 2 page?
283.
नहीं Annex A.
Annexure এটা start ହେଇଛି
283.
ଆମର 283 ରୁ start ହେଇଛି. You are referring to which page?
Page 291, my lord.
Hmm.
291.
Hmm.
Yes.
Yes.
The charge.
The charges in Article 4 was that the CO remains absent unauthorizedly from 1811 to 9 to 2511 to 9.
Right.
And that was alleged by him that he was spared for WOD, that is waiting on duty, but not assigned any duty though he was ready. Full stop. In support of the said contention, he relied upon the sign-on/off register, which was not produced by the administration, though he filed necessary application. Full stop. It is further alleged by him that no intimation was received by him to appear before the fact-finding committee during the relevant period. Full stop. The witnesses Pidol 1 and Pidol 3 were examined by the administration to speak about the said charge IV have not spoken in clear terms that he was legally intimated. It is also relevant to mention that no communication in writing or by post was sent to him. Even the alternation in the attendance register by the administration was made without a notice or intimation to him. The administration has not placed any valid evidence to dispute the said averments of the suit. As far as charges in Article 3 and 5 are concerned, the administration has not produced any valid reason to establish that the CO has refused to accept the letters. Full stop. It is rather strange as to why such letters were not sent by post, as the same is mandatory. Regarding the charge in Article 1 and 2 are concerned, no valid reason are assigned by the CO to justify his stand. It is also necessary to mention that refusal to reveal the contents of his representation and directly sending to Honorable PM and His Excellency, the President of India, no doubt may be termed as misconduct. In this case, the application of CO for a mutual transfer was rejected, wrongly quoting the Railway Board order, which indeed was supporting him, and the same was communicated belatedly to him. Full stop. Even for the copy of that order and other relief, the CO was constrained to seek relief under RTA Act. In the given circumstances, such misconduct mentioned in the charge number 1 and 2 committed by CO cannot be equated with the gravity of misconduct defined in 3(1)(I) or 2(I) or 3(I) of the Railway Services Conduct Rule 1966. Full stop. That too in the absence of any alleged ulterior motive. The A also failed to consider the entire fact involved in this case, particularly the fact relating to mitigating circumstances in a proper perspective before confirming the punishment of dismissal, which is shocking disproportionate. It is also relevant to mention that both the DA and A have not made any finding that the CO has failed to maintain absolute integrity or devotion to duty.
The tribunal has relied upon this part of it and passed the order.
This is the advice of RRT, my lord, which is a statutory body, my lord.
In true sense, the advisory board says that none of the articles are proved.
Moreover, my lord, my service started in the year 4 and ended at 12. That means I have completed only 8 years. So there is no difference of compulsory retirement and dismissal because I will not get anything, my lord. And at present, I have 50. And in the meantime, my lord, I have already suffered more than 12 years, my lord, by remaining out of job, my lord. That is my humble submission before my lord for consideration.
You are bound by the advice. This is a statutory advice.
Nine.
Well, that is there on record, my lord, I cannot, what my lord, my solution is, my lord, the law and tribunal, when adjudicating, has a contrary to the.
Tribunal has only relied upon the statutory advice given by
Here, my lord,
your.
confirmed with regard to interference with the, my lord, AS order and, my lord, disciplinary authorities order and as well as appellate authorities order.
This writ petition has been filed by the Union of India challenging the order dated 10/10/2023 passed by the London Central Administrative Tribunal, Cuttack against Cuttack, number so and so. The opposite party, Rakesh Kumar Moria, filed the aforesaid original application with the following prayer. এই যে ওই নম্বরটা আছে তার পরে যে রিলিফ শর্ট ফরটা রয়েছে পেজ নম্বর 57 রে তো ভোট করবে the notice was issued to the petitioners and they filed the counter affidavit and the petitioner, especially the opposite party, filed the rejoinder affidavit also. The London Tribunal, after considering the pleadings and the submission made by the London Council for the respective parties, has been pleased to hold as follows. Quote paragraph number 14. The Land Council for the petitioners argued that the order of the London Tribunal is not sustainable in the eye of law because of the scope of interference in disciplinary proceeding and punishment imposed by the competent authority. He has relied upon the decision in the case of State Bank of Patiala versus SK Sarma. So answer the ground number 1 mentioned that if procedural provision has been violated in course of the proceeding and no complaint is made with regard to any prejudice caused to the delinquent, the court should not interfere with the decision of the authority exercising judicial review power. According to the Land Council for the petitioner, there is no violation of principle of natural justice or any procedural lapses has been alleged by the opposite party causing prejudice to him at any stage of the proceeding. Rather, the London Tribunal in the impugned order has been pleased to hold that that the tribunal is পুরো লেখা হয়েছিল যে ইন্টারফিয়ার করিবেনি বলি
মানে পেজ 268 paragraph 14 also.
Rather, the tribunal has been pleased to hold that it is not convinced to quash the charge memo, DA and AA order. And therefore, The land council further argued that when all the 5 charges have been proved, the punishment which has been imposed cannot be said to be shockingly disproportionate as observed by the Learned Tribunal. However, the Learned Council of Paragon, the Mr. Rautra Learned Council appearing for the opposite party, on the other hand, submitted, referred to, সেটা কোন পেজটা রেফার করছিলে সেই যে অ্যাডভাইসটা যেটা
192.
291 minor.
হ্যাঁ
292. Annexure counter annexure A.
হ্যাঁ
সেটা দেখুন, এটা হচ্ছে railway rates tribunal India under advice under section
that advice under rule 24(2) of the Railway Servants Discipline and Appeal Rules 1968 was sought for from the Railway
Rates Tribunal.
Tribunal of India, wherein
192.
150
92.
পেজটা দেখো যেটি সেটা
পড়িলে না 192.
wherein it has been 192 na 291,
291. Yes.
wherein it has been held as follows. जो कोट करिया
পুরা যেতে চার্জেস
जो चार्ज जोड़ा से मना করছেন जोड़ा সেটা কোড স্টার্ট হইছি মিস্টার
Again, first para the charges in article IV maila.
কোড পড়ুছেন
291 page ro
291 পেজ
first of para.
আচ্ছা
the charges in article 4.
हाँ the charges in article 4 say to court ये चल जाएंगे up to
Last এই করে
last time कर दिया था ना he further argued that the Learned Tribunal has relied upon this advice and has directed and has been pleased to report that the punishment of compulsory retirement is shockingly disproportionate and harsh to the charges leveled against the applicant. And
persuades to the right the disciplinary authority from dismissal to compulsory. That is the persuades to the advice rendered by the tribunal dated 4/6/2013. The disciplinary authority has revised the penalty from dismissal to that of the compulsory retirement, which was assailed before the tribunal by the respondents.
তারপর লিখুন,
And tribunal has given this.
the tribunal has directed for remitting the matter back to the revisional authority of the general manager of so and so for suitable modification of the punishment other than dismissal of the removal of the compulsory retirement and issuance of consequential order. After going through the advice given as per
Advice rendered by
advice rendered by the Railway Rates Tribunal of India,
which
4/6/2013.
is statutory in nature.
which is statutory dated, it is
4/6/2013.
4/6/25.
2013.
3/6/2013.
13.
3/6/2013. We are of the view that there is no illegality in the impugned order, and therefore we are not inclined to interfere with the same. But I stated at the bar that a content petition is also pending before the London Central Administrative Tribunal since the order has not been complied with. So the concerned authority shall complete comply the order for them, comply the order so and so. So time they do
4 weeks.
within a period, you complete it within a period of 4 weeks from today, according to
The indication of the tribunal is to give a minor penalty. You have converted one major penalty to another major penalty.
My lord, I mean, pardon. Disciplinary authority has not reduced the punishment. Lords, may revisional authority reduce the punishment and dismissal to completion. That only
Revisional authority. Okay. And you give it and we'll correct.
draft.
Correct it.
What is till then not to proceed with the.
No, my lord, only because this writ petition is pending, I am seeking adjournment in the contempt from time to time, my lord. I
Now
want
it is under the principle of merger, now it goes that tribunal, the content petition goes.
Content petition now.
yes, sir.
Now our judgment is
Obviously.
We are filming.
Item 15.
Yes.
15 kindly pass over on behalf of Mr. Manoj Mishra. Please.
Item 16.
May I please? Petitioners, before your honor, challenging the order of the London Central Administrative Tribunal, rejecting the claim of the present petitioners for regulation, even though petitioners are working against sanction posts since 1993 and receiving a revised scale, 5th scale and 6th CPC scale from time to time. And because of the pending of the case before the London Tribunal, 7th pay was not revised. And the London Tribunal rejected the claim of the petitioner for regulation. Your Lordship, kindly see Annexure 1, Series page 25, my appointment orders. Initially, the petitioners were appointed on 89 days in a considerable amount of 2,000.
Okay, you come to paragraph number 11 of the impugned order, which is at running page 119.
The examination of the facts and the law discovered, we find that initial engagement of applicants were on contractual basis without following due process of law, rule, public law, and not against a regular bank. This is wrong. Not against a plan, this is wrong. It is also not established that the applicants have been continuing on such agreement uninterruptedly. The other, we find that they were given opportunity to complete any selection with others, but they did not find any breadth. I will satisfy this respect is concerned. I will satisfy my lord. That of the petitioners were appointed against sanction post.
Please read.
My lord.
Please read it further.
Man, backdoor entry in a public employment has been deprecated by the Honorable Appeals Court time and again. In the said premises, we do not find violation of any substantial fundamental rights of the applicants or, for that matter, any promise held out to them at the time of their initial engagement on contractual basis. The respondents, in complaint of the decision of the Honorable Appeals Court in the case of ML Kesari Supra, taken step as one-time measure for regulation, but the applicants did not qualify there. We have taken into consideration citations relied on by the London Council for the applicants in the case of Shaktipad Mahapatra versus State of Odisha and others, civil appeal number so-and-so, and Amarkant Rai versus State of Bihar and others, so-and-so report and so-and-so decision. We find that the facts and issues involved in the two decisions and the other decisions noted in the preceding paragraphs are completely different and distinct to the facts of the case in hand, and therefore we are of the considered view that the above two decisions have no application in the instant case. In so far as the allegation of the applicant that Sri Kamakhya Prasad Dubedi, who was appointed initially on contractual basis, having been regularized by the Protector 25/893, they have a right to be regularized is considered. We may state that applicant having kept silent when Sri Dubedi was regularized on 25/893, at this later stage, there is no ground of law to claim the said benefits because once it is established that the applicant had no legal right of regulation merely because some irregularities and illegalities have been committed by the respondents in some other cases with respect of regulation that would not confer any right upon the petitioner to claim parity. The right of equality and Article 14 and 60 of the Constitution, a positive concept and not negative one, are held by the Honorable Appeals Court in the case of Postmaster General Kolkata and other sources. In view of the discussion made above, we find no merit in this case, which is dismissed accordingly, party to bear their own. Your Lordship, kindly see my appointment. Initially, I was petitioners were appointed on 89 days basis, and except to page 25 minor.
You come to the date chart that is there, 1993.
1993.
Right.
on constituted basis, my appointment is 1993.
Hmm.
Our appointment is 2 petitioners, my lord. Thereafter, from 7999, we have been extended, my lord. Fifth scale, since we are continuing against sanction post, the pay scale attached to the post has been given to both fifth and sixth pay. Unless there is a sanction post, no scale of pay will be extended. Your lordship can see, accordingly, we made application for a fifth pay. My application was recommended annexure 2, page 27. Your lordship kindly see,
Your posting was junior accountant.
junior account.
Okay. And there is no dispute that post was lying vacant for which against which.
My lord, let me satisfy you, that is no dispute. But the tribunal have wrongly held that not against available vacancy. That is
That you are disputing.
mine.
Your case is you have been appointed
Irregular, not illegal. Tribunal held that appointment is illegal.
as against the regular vacancy.
Against regular vacancy. A person if appointed against regular vacancy,
Because
he should be given the
perhaps
regular
the
scale of pay.
applications were sought for and accordingly you submitted your application and
Partition.
many others must have been, or you are the only person.
No, my lord. Initially, I have, through limited departmental examination, I have applied for regular absorption. They
Come to this, your initial appointment letter, that is page number 25, annexure 1 series,
my lord,
wherein it is stated that in consideration to his application dated. So how you came to know, how you submitted this application? So you are telling that it is a irregular and not a illegal. So how do you know that such a post is lying vacant for which you submitted your application? And they also gave you the.
after you also rightly pointed out, my lord. After my appointment, since the petitioners were appointed against sanction court, I made an application to extend the fifth scale of pay to the present petitioners. And your lordship, considering our application, they recommended and allowed fifth scale of pay, and subsequently also sixth pay has been extended to the petitioners with DA and ADA. Your lordship can see annexure 2, page 27.
Annexure?
2, page 27.
Yes, that's weird.
Subject, my lord. Daily wages rate of payment of Sri Prashant Kumar Das, working as junior accountant, Sai Sports Authority of India, SAG, Water Sports Quarter, Jagatpur, engaged on consolidated payment, and Surit Kumar Naik, petition 1 and 2. One is Prashant Kumar Das, second is Surit Kumar, working as junior tribunal. I am directed to forward here with the xerox copies of the note sheet so and so duly approved by the director in charge. My data for further handing over the Sai Water Sports Jagatpur, Orissa, Sai Training Center, Dhenkanal Stadium, Dhenkanal for further their action. The lordship can see the note sheet enclosed, my lord. Page 28, my lord.
Yes.
Last para, your lordship kindly see. If kindly approved, the director in charge will may forward his representative secretary Sai, New Delhi, to consider his case for payment of wages at the minimum pay scale, which is meant for junior accountant as recommended by the assistant director Sai, SAG Center, Jagatpur. This was approved in the next page, my lord. Page 29. Page 30 also approved, my lord. Thereafter, petition was extended fifth scale from 17,999 without any interruption. They continuing. And when sixth pay was introduced, my lord, they made an application. And my application was forwarded. And your lordship can see page 31. For sixth pay. After getting fifth pay, sixth pay application was forwarded. For your lordship can see page 31, my. May I read, my lord?
Yes.
Forwarding the application of casual staff posted at the center for payment of salary wages as for sixth pay commission. I am here with forwarding 2 number of applications submitted by casual staff Sri Giridhari Khatua, Night Watchman, Sri Surit Kumar Naik, junior accountant regarding payment. Surit Naik is petition number 2, my lord. Since they getting fifth pay, thereafter my claim was plus sixth pay against sanction post was written. Your lordship can see page 32. There may be paid minimum pay in the pay band plus dead pay attached to the post along with the DA revised time with effect for April 2011. Order was passed on page 33, my lord, in respect of petition number 1. Serial number 1, Prasant Kumar Das, junior accountant. This is relating to sixth pay commission recommendation. And page 34, my lord, order was passed, they may be paid minimum pay, dead pay attached to the post along with the DA revised from time to.
You participated in the selection process.
Thereafter, my lord, what happened, my lord? Next 3, my lord, page 35, for filling up the vacancy of the junior accountant, application circular was issued on 5/9/2000. Page 35, my lord.
Yes.
I am reading, my lord.
You have participated.
I'm saying, coming. Filling of the vacant junior accountant site through departmental examination. The competence decided to hold departmental exam on the, and your lordship, I have applied, but they did not consider saying that I am casual employee. Your lordship, kindly see serial number 2 and serial number 5. Serial number 2 is petition number 2. Serial number 5 is petition number 1. Right side column, kindly see. Surit Kumar Naik, right side column, casual employee, not regular employee side as per his application. A casual employee will not get 5th and 6th pay scale, my lord. Because they are casual employee, my case was not considered. Our case was not considered. And so far as serial number 5, Prasant Kumar Das is similar. They are saying casual employee, not regular employee of the SAR. My case was not considered. Again, my lord, Annexure 4 circular was issued for filling of the post. The lordship kindly see page 36. In 2002, the eligibility criteria, lordship kindly see page for the post of a junior accountant, page 37. Qualification. For the post of a junior accountant eligibility, lordship got my lord.
Yes.
Become degree from recognized university. Petition number 1 having income degree, petition number 2 having become degree. Both are eligible. So far as the qualification is concerned. The lordship kindly see, again, my lord, Annexure 5, page 39, my lord. On 12th August 2002, application was invited for junior accountant and other posts. The lordship kindly see the junior accountant post is become, essential qualification is become, and petition are made in paragraph 9 of the writ petition. Para 9 and page 5 of the writ petition, I have submitted that in pursuant to this circular, the petition is applied. But they also did not consider recommended by name, they recommended others' name, saying same thing that ineligible because casual employee. My humble submission, my lord, casual employee is not getting 6th pay, 5th pay, revised scale, are not getting. The petitioners are getting 56th pay. And honors, Annexure 7, my lord, they recommended others' name. And Annexure 6 also, my lord, they fixed the time of the holding selection. And they recommended others' name. Our name was not recommended. I recommend page 42, the 12 name recommended. Our name not recommended, saying that earlier stand they taken that casual employee not considered. My lord, thereafter, Annexure 8, your lordship kindly see, this is important. Your lordship pointed out whether you participated why they found that petition is not eligible. Annexure 8 was issued in 2010-11 financial year. Your lordship kindly see the junior accountant qualification, essential qualification, your lordship got it, my lord.
Yes.
Bachelor of Commerce become from a recognized university.
Age limit 18 to 27.
Right. Age limit 8 to 27.
By that time, you are.
I was allowed. In pursuant this.
Age relaxation was given to you.
In pursuant to this, my lord, advertisement, the petition was applied. Your lordship kindly see page 47. What is the selection criteria? Clause 5.3, man. May I read, man? Page 47, clause 5.3 of the advertisement.
Now both of you have become about 59 years.
Minor. There's minor clause,
You are continuing.
continue, without any interim protection. Because of this pendency of this tribunal and before this annulment, they are not extending 7th pay. Otherwise, we would have got 7th pay. Clause page 47, clause 5.3 minor kindly see. The candidates, may I read me? The candidates would be selected out of the merit list prepared only on the basis of mark secured in the written test. The candidates would have to secure minimum 40% marks. In 33% mark SC/ST to be eligible. So for SC/ST concern 33%, generally 40%. Petitioner belongs to general category. The Lordship kindly see, and thereafter your Lordship, however, the written test would be followed by a skill test, that is typing test for LDC with the minimum speed of 35 word per minute in English, 30 word per minute in Hindi, so on so. And junior accountant skill test on MS Excel and Tally software on computer, qualifying marks 40% out of 100 marks. So also, a total number of candidates 5 times of the number of vacancies would be asked to appear for the qualifying skill test. A final merit list would be prepared among those who qualify in the skill test. Post would be offered to candidates based only on merit list prepared on the basis of marks secured in the written exams.
You have not qualified.
No, I qualified in the written exams.
40% you got.
More than 40%. They taken the stand before the honorable tribunal that the petition did not qualify. Therefore,
where from I will get that 40%?
Your Lordship kindly see, page 51 admit card was issued to the present petitioner.
Oh, admit card, forget you. 40% you got.
Admit card for written test. And Your Lordship kindly see, page 51 and 52 is my admit cards. Surit Kumar Naik and Prasant Kumar Das are admit card. And page 53 is the merit list securing the marks.
Where is your name?
Starting from page 53.
No, where is your name?
My lord.
Number?
My name, my lord, is serial number 152. Surit petition number 2, Surit Kumar Naik, serial number 100, page 57, my lord.
How much you got?
46.
46.
So for a petition of 40% mark, minimum marks is 40%.
Then why have you, why they?
Lordship kindly see petition number 2 marks. Tribunal did not consider this aspect, saying that it is ineligible. My lord, ineligible and suitable is a different thing. Lordship kindly see, so petition number 2 is concerned. His name finds place at
This
page 55, serial number 88. Serial number 88, my lord.
I'm appearing for it. Yes, you will exploit a man this not regularize his case. He is working since 1993. Well, we are in 2025 and he's already 58 or 59. So
You see, you have given them 6th pay commission, this thing, and they participated in the written test. They've also qualified 40% marks they've got. And everything has been done. And they have qualification. They have been working for such a long time. They have experience.
Tribunal saying I am not eligible. Become qualification, become petitioner was the employment.
junior accountant, the initial appointment in 93 and he was having the qualification. It's not that
On the date of office.
You consider their case.
Let's say, may kindly see the impugned order.
Impugned order is wrong, therefore he is challenging.
Not before that, initially the petitioners have filed an application which your lordship may find from Annex 15.
no, will not
he was
go
allowed.
all those
No
things.
more
But
technicality.
He
technicality,
was allowed.
See,
If
think
I-
over. What will they do at this stage?
a person who has worked with you for last 32 years
Yes.
and discharged the duty, and you have also given
Sick
the
pay commission
sick
and
pay commission, everything. So now you are not regularizing him after 32 years, and technicalities will be there, this,
Yes.
that, and initial
For
appointment.
denying, there is a lot of technicality.
I bowed
For
down
giving,
also.
there are also, there are a lot of ways.
The Sports Authority of India, guided by certain rules, I will demonstrate, Your Lordship. The other eligible persons granted Millard regulation. The petitioners initially approached. They are allowed to be observed in Group D post. Your Lordship may kindly see. They have
become-
now developed the case by amending the application, where my Lord kindly see page 104.
Group D post means peon.
Yes, no, my Lord, that is kindly see on the learned tribunal.
You
But
utilize them for 32 years,
Sir,
now you say that. peon.
You Lordship may kindly see.
On the wrong
Counterpied by the
You have
respondent.
issued the initial order to join as junior accountant.
Yes.
Now you're asking that you go and
11 and 12, you Lordship can see page 108. I'll just place two paragraphs, it was in their favor.
that
And they
judgment,
will not file review application. And also the respondents, I also filed a writ application challenging the Millard.
See,
Yes,
now
sir.
you concede to the fact that you
No.
are ready to give Group D. 1 minute. You are ready to give Group D.
Even Millard, they're not eligible. They're not eligible because.
Group D also they are not eligible.
Millard, that also we have challenged. We have.
that is what the exploitation comes. Person, you issued them the letter right from 1993. The appointment.
Do something.
You Lordship may call this matter next week. I'll come.
Do something. Do something.
I'll also check up under some document they have filed the writ application which are not in the original.
Since Lakon.
I'll take instruction and
I need also lots of time.
next
It's
week.
very harsh case. You.
I'll assist your Lordship to come to a conclusion. But they have filed certain documents were not initially in the lower court, and now
Come with a positive
I'll
instruction,
check.
that's all.
if someone
Petitioners who are initially appointed and joined as junior accountant on 1/9/93 and continuing since then, and they have even given which on which date that sixth pay commission
Sixth commission minor was given on
date account
minor.
upon date chart election the
Again. Lots of times. That's a
Dates are busy. We didn't check.
sixth pay minor has been given.
11, 12 of page 108.
The pay of the petitioners have been revised under the sixth central pay commission scale of pay with effect from 6/6/2011 and 16/8/2011 respectively. And now are aged about 58 years.
There is a number 32 years.
And worked in the organization for more than 32 years, are aggrieved by the rejection order, by the order dated 25/7/2024, passed by the Lenin Central Administrative Tribunal, Cuttack Bench, Cuttack in TA number 261. So, in which their prayer for regularization has been rejected. The Land Council appearing for the opposite party Sports Authority of India
2 to 4.
2 to 4 submits that some time may be granted to obtain necessary instruction regarding regularization of the petitioners, taking into account their continuous service for more than 32 years.
Lordship may record my that I will take instruction.
Stop.
That's instruction.
Stop. Put up this matter. So any kind of indication we will give, they will turn down. So and so put up this matter. And we come in from 18th August 2024.
Actually, as partner.
This court expects, this court expects that in view of the continuous service for so and so, the authority shall consider the case of the opposite party favorably Hola? Yes.
But 3 weeks time because I have to attend the Delhi. 3 weeks after.
I am actually the opposite party number one.
The line counsel for the opposite party number 1 is present.
Continue putting in service, continue.
The petitioner still continuing in the service and working as junior accountant.
You Lordship will indicate that flag B, my counter is there, that you Lordship will.
As the
We'll
junior
consider on merits.
Well, no, you Lordship will consider, but
sports training
because
center, Baravati
so
Stadium.
far my,
So also, National Center Excellence is also. Though the counter affidavit, though the
You are
counter
saying that we
affidavit and
can-
rejoinder has been filed, but in view of so and so, a continuous period of service, let him obtain instruction, right? Yes, next.
but my objection may be recorded because there will be no such thing.
No question of mission. We have stated that
You
we are passing the
Yes,
instruction.
Lordship pass order, you Lordship record, I have objected by filing a
All
counter.
right.
That,
Next.
That will be your
you
return.
Lordship record, that to authorize the authority. I will instruct them
Hmm.
to.
Yes.
Next.
Item 17.
Who?
My lord, I am filing the counter affidavit today, my lord. Permit me, I will file it here.
What is challenge here?
Lordship kindly answer the petitioner. Lordship kindly look to order dated 12/9/2024.
The sale certificate has been issued all.
Here it is a challenge for disbursement of the interest amount which has been kept by the bank for about 7.5 years.
You are the,
I am the highest bidder.
okay,
I deposited the amount of 30 lakhs,
okay, then,
30.25 lakh.
right, then what happened?
Then the land which has been auctioned,
Huh?
it is intimated by the bank that some part and portion of the land has been acquired by Swaraj Board.
Okay,
Thereafter, I wrote a letter to the bank that rest of the land may be sale certificate may be
given,
issued.
yes,
They didn't issue that. They
okay.
again put the property to auction
Mhm.
by keeping my money with them.
Okay,
And ultimately, it has been sold to
Someone else.
No, his wife. His wife.
my wife. I requested them to adjust the amount in the auction amount of my wife.
yes,
But here in the, I have deposited the amount on 30th of April 2016,
16.
and the same has been adjusted by the bank on 20th of October 2023.
You want interest part.
Interest part.
What is your instruction?
And I have been filing my counter affidavit.
Hmm.
He has been intimated immediately thereafter the sale has been cancelled because the acquisition of land has not been intimated to the bank. Because it is intimated to the borrower.
Why you have not refunded his money?
Refunded?
We have given the letter, take the amount, and he has not taken the amount.
No,
He had an account in your bank?
No.
he deposited it in 34.
Yes, we have immediately sent mails, and thereafter he given the letter that you give the rest portion amount. We denied that we cannot give the rest portion amount.
No, you come to that particular paragraph.
Your lordship may
Yes,
see.
you are not disputing that on 34/2016,
Yes, madam.
30.25 lakhs have been deposited.
Deposited. madam.
Only what you are saying is we asked him to take it back, he is not taking.
No, he has not
He didn't
taken.
take.
madam. He is insisted for the rest of the land, which could not be done.
Leave it.
And thereafter another-
He is not on that point now. Only for this interest part he has come.
Madam,
So
on his request, we have adjusted the said amount to the wife accounts.
No,
that's
interest
all
part.
right. Interest part,
Interest part is-
interest.
And your lordship may see the mail sent on 15/3/2016.
But fact remains the money stayed with you. You might have utilized that
There is
money.
no fault on our part because we cannot
What?
keep it in an
Sir,
interest
bank-
bearing account, madam.
You pay-
We cannot keep it in an interest bearing account. It is the condition of auction, my lord.
Only 2 days.
And the judgment cited to this case, there is a.
If not 10%, you can reduce the interest rate. and
Madam,
give
it
some.
is his case. In the read petition, he has stated that he adjusts the amount deposited by me in my wife's.
That is after
you have done
this
it.
second one.
Yes,
That
madam.
you have done.
Yes,
That-
madam.
That 30.25 lakh, there is no dispute about.
No, madam. That is,
Question is of
Interest
the
on that.
interest on that.
and as per my submission, is that he is not entitled to get the, because immediately we have wrote the letter immediately after cancellation of the sale.
We have wrote the letter to him.
That you have annexed as annexure
Yes, my lord. The
A by 1.
yes, my lord. Email sent to the on 15/3/2016. The bid has been held, my lord. Immediately on 28 July 2017, and also one is on 28 July 2017 and as well as 18th August 2017, my lord. Again, the same mail was forwarded to him, and the petitioner is in writ petition also stated that he has again, after getting the mail, he has requested to give the rest portion of the land to him. Your lordship may see the jet chart.
In any case, at least he is entitled to interest for 1 year.
For 1 year, he is
So
entitled.
therefore, we are sending it to mediation.
Yes,
Sort
ma'am.
it out.
Yes, ma'am.
But then the land counsel for the opposite parties number 1 and 2 file the counter affidavit, which is taken on record. The petitioner in this case has prayed for interest on the deposit of rupees 30.25 lakhs made on 34/2006 till the same was adjusted on 28/10/2023 at the rate of 10% per annum with stop. The land counsel for the Mr. Biswal land counsel for the bank submits that a letter was issued to the petitioner regarding cancellation of the auction held on 15/3/2016 and for refund of bid money on 28/7/2017. And thereafter another letter was issued on Kebe
28 July 2000.
Federal Gala Private.
18 ତା ତଳେ ଅଛି sir.
ଆଉ ଗୋଟେ ଯାଇଛି
18 ଅଗଷ୍ଟ 2017
18
ତଳେ ଲେଖା
July
ହେଇଛି।
82.
Aja, another on 18/8/2017
ସିଏ କରୁଛନ୍ତି 4/5/16 ରେ ତାଙ୍କୁ intimate କରାଗଲା ତାଙ୍କ ଡେଟ୍ ଚାର୍ଟ ରେ ଲେଖିଛନ୍ତି 4/5/16
the petitioner
informed that-
also admits in the writ petition in which paragraph
in date chart 4/5/2016 my lord, CMC.
in the 4/5
2016
no ସେଟା ସୁଏଜ ବୋର୍ଡ
ନା ସେଟା 4.2 ସେ ତଳକୁ ଦେଖନ୍ତୁ has been acquired by Swaraj board for which the petitioner was called upon to take back the deposited amount.
acha
4/5/16
in the date chart also the petitioner has mentioned about the bank's intimation take back the given to him to take back the deposited amount in view of the nature of dispute the worship format mediation taken.
And the next date, on 5/5/16 from the date, petitioner requested bank to allow the transfer of balance loan. But that has not been adhered.
That's what he's saying. He's not possible. You are insisting for that. Despite the fact that they're requesting, you are not taking money. No, you give the land.
I have received today the counter affidavit along with the letters which has been annexed. So I'll take instruction by the.
A copy of the counter affidavit has been served on the land council for the petition. Asu report asu যদি
Alert.